Welcome, folks, to today's Wisconsin Facets webinar for January 25th, 2022. This is Section 504 in Education, What Parents and Schools Need to Know. My name is Matthew Zelmer. I'm the Parent and Youth Services Coordinator with Facets, and I'll be your presenter for today. As I mentioned at the outset, most of you are on. Your lines are muted because the presentation is being recorded. You will have access to that recording following the webinar. In the event you cannot stay on for the entire presentation and or would like to share the information with someone else after, you'll be receiving an email with a recording and a SurveyMonkey evaluation about an hour after we wrap up today from GoToWebinar, not from me or from Wisconsin Facets. So please watch for that and let us know how we did on the evaluation. So without further ado, let's take a jump into some content. So first of all, to establish a baseline, what is Section 504? And you see it there, it's part of the Rehabilitation Act of 1973 and is a national civil rights law which grants equal access to qualified persons with disabilities to all programs and activities receiving federal funding. And we'll talk a little bit as we get into it about what a qualified person with a disability means. But the theme regarding federal funding is going to be something that we're going to come back to probably at a few points to know how important that is. And finally, the ADA Amendments Act of 2008, which we've provided a separate handout for you with some information on that, modified some parts of Section 504, we think certainly in a good way for persons with disabilities. So I'll just kind of let this wash over you what Section 504 actually says. This is taken from the legal language of the law, but basically it's an equal access law for persons with disabilities. It also applies to race, gender, sexual orientation, etc., protected classes. But for the purpose of our work, as we're a parent training information center serving families of children with disabilities regarding educational services, we are going to focus on disability and what that means for parents and schools and our kids in the world today. So what types of schools then does this law apply to? Basically all of them which receive federal funding. And you see the list ranges from early childhood programs like Head Start right on up through the university level. So the key is the school receiving federal funding? Then they would need to abide by Section 504. So it certainly includes all types of public schools. Remember that charter schools are public, so that would apply to them as well. Private schools or choice program schools, the key question really becomes, again, do they receive federal funding? Because at least here in Wisconsin, school choice implies a private school. So if you're a parent making a school decision, for example, where to send your kid who has a disability or you might suspect has one and would need a 504 plan, and a private school is on the table, inquire, do they receive federal funding, or research it, so then you know going in at least a little bit about, might they be able to meet the educational needs of your child. So what can a school district not do under Section 504? And again, I said in the open, this is an equal access law. So what that means is they cannot discriminate on the basis of disability or suspected disability, deny accommodations and modifications, deny access to programs, facilities, or services, and they cannot provide programs or services that are not equal in nature. And by that, we mean those offered to the general population of students, otherwise known as those without identified disabilities. A school district also cannot provide programs or services which aren't as effective as programs or services for that general population, and they cannot provide different or separate services unless necessary to provide equal opportunity. And the example that always comes to me on this point is, many of you have probably heard, particularly if you're in a larger population area, about special needs proms being put together. Prom is obviously a big group event, lots of kids there. Things might happen that we would consider a little questionable or unsafe for some. So, with respect to the high school experience, groups and parents and schools have sometimes collaborated and put together a specially designed prom for those with special needs to keep them among their peers, keep them safe, have it be a little more low key, perhaps more sensitive to the likely sensory needs of some of the students. Such an event would be okay and not a violation of Section 504, more than likely. And I should preface all of this by saying we're not a legal services agency at Facet, so we cannot give legal advice, but that's an example to me of something that would be okay to provide a different or separate service to a student with a disability, and be perhaps necessary to provide equal opportunity. If anyone out there has a different example or even a more germane example to this, feel free to pop it into the chat and we can comment on that later for the benefit of our audience. So I've told you a little bit about what schools must not do under Section 504, which of course begs the question, what must they do? What do they need to do? So all of this, there's enough points here to be divided into two columns, as you see, but all of this are things they must have in place and do. So this is all things that we need to pay a lot of attention to. A written assurance of non-discrimination in a student or parent handbook, or in this online world on a district or school website, would be an acceptable format. Typically, I think it's both, because if it's not accessible to some, or not readily accessible online, you can ask for a printed copy of any handbook like that as a disability accommodation, in fact. They must also have a designated 504 coordinator. The thing to know here is I have never seen in any school environment a 504 coordinator who has just that responsibility. And it's certainly possible that one or two of you today on the call might be tasked with some of that responsibility if you work in a school building. But for the parents out there, which is our main consumer group at Wisconsin Facets, we always say that find out who that designated 504 coordinator is. Most commonly, it could be the school psychologist, counselor, or social worker. This is to happen at the school and district levels, but I've never seen or heard it where a 504 coordinator, that's all they do. So it's somebody who likely has one of the school roles that I just mentioned. There is at least a little bit of training to obtain to go through that I don't have specific information. If anyone has this question out there about where to get that, it's something that you would ask your district as part of professional development. Inquire about receiving any 504 training. But for now, moving on, so find out who that designated 504 coordinator is, because that is the person that is aware and would need to distribute, as this comes up, the procedures that the school and district have to resolve complaints that might be filed under Section 504. And the 504 coordinator should be the main point person to provide the parent or guardian with procedural safeguards once they would be engaged in a 504 evaluation referral process, the implementation and development of a plan, and grievance procedures, which we'll touch on a little bit toward the end. At any point, the 504 coordinator, especially when asked by the parent, needs to be able to provide a parent with a book of procedural safeguards or a link to them, and it's something that districts must have. The final district obligation for this slide is to every year identify locate all students with disabilities or those suspected of having an impairment within a district boundary. So we're going to touch on this in a couple different ways throughout today's webinar, but IDEA versus Section 504 has some differences in qualifying for services. Eligibility we'll talk about this momentarily. There's a bit of a lower bar to clear in terms of eligibility for Section 504 than there is for an IEP under the Individuals with Disabilities Education Act. But just because a child doesn't qualify under IDEA does not mean that he or she won't under Section 504. In fact, in many cases, it can be just the opposite because of the criteria we will get to right about now. So what is to happen if a child is to be found eligible for 504 protections and with them a potential 504 accommodation plan? They must have a physical or mental impairment or a record of having an impairment or are regarded as having an impairment which substantially limits one or more major life activities. So back up to point one, it can be a common misnomer, hopefully less so than when I started this role about 13 years ago, but I still hear from time to time from a family that they were told that their child would not be eligible under Section 504 because the impairment is not physical in nature. You see it there, and it is an or in its key language. It can be a physical or mental impairment, and I'll touch on the record and regarded thing in a little bit. Substantially limits we'll get into subsequently, but substantially limits is the key legal phrase there. One or more major life activities to qualify under 504. In a bit, you'll see the list of major life activities. Substantially limits, however, is not clearly defined in the law. So there can be discussion in evaluation meetings, certainly around even after an impairment has been identified, whether it substantially limits. So we've thrown this in here for you again to underscore that this first requirement of having an impairment is an or. So A, B, and C is an or. It's not three conditions to determine whether we have an impairment. So the record of having an impairment or regarded as having an impairment are things that are kind of murky in a way, but it could be something under this like that's episodic in nature, like a seasonal illness or disorder, post-concussion syndrome or chronic concussions, even constipation, I suppose, could meet this condition. If a cancer diagnosis is in remission, that can be a record of having a past impairment which impacted the student significantly, or similarly being regarded as having an impairment. There are not, as a practical matter, a lot of disputes that we hear about in Wisconsin that the qualification comes down to points B and C here. It's more about point two, which we'll get to now, but if anyone has questions, just kind of process that, file your question away, type it in the question box, and we'll get to it. So as I mentioned, substantially limits is not clearly defined in Section 504, which is not a great thing, admittedly. However, and this is largely why we included the ADA Amendments Act of 2008 handout for you, mitigating measures can no longer be considered when determining whether an identified impairment substantially limits. And it may not sound like it, but this is good for our kids, our students. And for example, in the past, before the ADA Amendments Act, it was okay for a school to say, well, we've identified you as a 504 team as having an impairment, but because of the mitigating measure of, let's say the impairment is ADHD, and the parents have chosen along with their doctor to medicate the student, it's working. So therefore we don't have to give you, supports such as a visual schedule, or, fidget toys or movement breaks or something that might be impacted with that particular disability. So this ADA Amendments Act said, if you're eligible, you're eligible for whatever reasons you would be eligible. Now, the only exception to mitigating measures not being considered is in the case of standard visual impairments, like those that might require a person to wear glasses or contacts. I don't have my webcam on right now. What you guys can't see is I'm a wheelchair user, so that as a student would have made me 504 eligible because I had certain impairments that substantially limited major life activities, but I would not have been eligible due to the fact that I wear glasses, and I'm wearing them right now. Same thing with contacts. So if it's a visual impairment that is mitigated just by standard prescription glasses, then that alone does not qualify a student for, that impairment alone does not qualify a student under 504. Now, if it's a deeper discussion of low vision and the need for vision services, that's a whole different ballgame. So here then is the list of major life activities. I usually give the disclaimer that this is, I'll back up, this is not an exhaustive list, but as we read over this, I can't really think of a category that's missing from it. So you see how long this list is the point. So anything having to do with learning, there's a lot that it is physical in nature, self-care, thinking, communicating, concentrating, major bodily functions are all in here, among other things. So it is a long list. That's why the key to this is the substantially limits piece, and why we like the fact that mitigating measures are no longer considered when determining 504 eligibility. So, okay, this is actually our first, starting with this next slide is our first natural stopping point. We've got a number of people on. I'm going to take a drink, but I'll pause to give you an opportunity in the audience to type any questions you have into the chat. We'll dive into the more of the makings of 504 plans themselves over the second half. But if there are any questions I can answer regarding what's been covered so far, you may type them now. And I do see at least one coming in, so I will bring that up now. If it'll go. There we go. We have a person asking, are there any long-term problems if a child is not given IEP, but is given a 504? So that's one of those things to our asker that could be a longer conversation, but in short, I would say, yeah, absolutely, there could be long-term problems, and it's a conversation I have with parents here more frequently than I care to. Sometimes it has to do, there can be any number of reasons, but sometimes that development has to do with the perceived level of need the parents and schools simply disagree, hopefully based on the evaluation data, about what that level of need might be. How significantly the impairment is impacting the student's learning could be part of it. Hopefully, though, the discussion is centered on data. It's not supposed to be based on simply on the feelings or the thoughts or emotions of either party, parents or school. But that, there are rights that parents have, and this is not this particular webinar, but there are basic rights that parents have to disagree with the IEP team's conclusion and continue the battle to get their child an IEP if they feel or they may have outside data that would suggest they could be, I'll say, IEP worthy. So that's what I will say about that for right now. If you want to talk further following the webinar today, I would be happy to. You'll have my email address and phone number at the office if you need to get a hold of me. So that person says thanks. So two other comments or questions chiming in. Looks like I should have figured we would have this one. How do mask mandates impact the district's ability to serve a child that cannot wear a mask due to their disability? That's as you might imagine, that's a situation that is widely varied and kind of still evolving. It's a discussion that really needs to be had up front. Parents should be as united as possible with their doctors, and we always recommend medical documentation from the doctor in a case like that be given to the school and obtained before parents would have a meeting with the school team and kind of make their case for that. As a practical matter, what we've seen since the pandemic has been more along the lines of if there's a mask mandate in a school, it's working the 504 plan or the IEP, but since we're talking about 504s, working the plan so that there's mask breaks, of a certain amount and frequency written into that, some condition in which the child is not required to wear a mask the whole time. I can't speak in as much detail to what kind of detail would the schools be looking for in a doctor's request. Keep in mind that all outside presenters, outside experts rather, can do is request and recommend that a school do something. We can't mandate it. So it's a collective effort, parents coming in prepared with medical documentation that specifically outlines the reasons why there are limitations with the mask or it can't be worn. And we have heard this, like wearing masks causing an anxiety attack or exacerbating that condition, but it needs to be hammered out, and then whatever is decided needs to be in writing, clearly, directly part of the 504 plan. So not a separate health plan, because the only thing that has a legal backing is a 504 or an IEP. So I hope that makes sense. And as always, we can talk more about that after if you would like, because I generally anticipate that questions are coming not from a pure hypothetical, but from a situation that parents or professionals have seen or have on their hands. So this one says, wondering who is the person that usually heads up 504 plans at universities. We'll get into that a little bit later, but the process for you, if you're wondering, would be the same, though finding out who, like if there's a designated compliance person would be the start. And I would do this earlier than later in terms of if you're helping your child through a college visit and selection process, it's one of the elements to consider is who can we meet with to talk about accommodations. But we actually have a mini section on some of those issues coming up. So hopefully you can stay on. If not, be sure to access the recording. All right, and then one more. For right now, it says, why doesn't the school know about training the teachers for students with autism? So that's a broader question. I do appreciate that you're asking it. It's clear to me that that's child specific. Anything we're talking about today um, is not necessarily disability specific, although we know that autism is a common diagnosis and lots of kids out there have IEPs and 504 plans because of it. Teacher training, though, I will say this, as we begin to look in this next section about accommodations that can be provided within 504 plans, teacher training based on individual needs of the student is absolutely a thing that can be discussed and decided upon as a need and put into a 504 plan so that a school must do it. All right, I'm going to move on. So, as folks out there think of stuff, the next general break for questions is going to be at the end, but we're about halfway through and doing pretty well on time. So, we're going to move on to a little bit more of the particulars about Section 504 accommodation plans themselves. And the takeaway here is simply really the last sentence. We always say if it's not in writing, it doesn't exist, but the content of plans may look very similar or very different than an IEP, whether an IEP has been had prior to discharge from that and developing a 504, or whether it's a simple 504 need from the jump. The plans may look very similar or very different, but all based on individual needs. And my screen is freezing, so have to, oh, there we go. Make sure I didn't jump. Okay, we're good. So, as I just actually mentioned, services must be individually designed and provided so they meet the educational needs of students with disabilities, the same under 504 as with IEPs. They're governed under different laws. You don't have an IEP and a 504 as plans at the same time, but in that respect, they're very similar based on individual needs, and they are legal documents. So again, the main thrust of the law is going to be that equal access. Services should be designed so that students with disabilities have the same access to all programs provided by the school as students without disabilities. This includes, by the way, extracurricular activities. Not going to say there's no exceptions, because remember, unless necessary to provide, equal support and services, prom example that I touched on. But overall, the law is in place to make sure we don't lose the equal access piece. So examples of accommodations and modifications that would be certainly acceptable and are commonly used under Section 504 and in 504 plans. We're not going to spend a lot of time on these, but there's a few slides worth of them. So removal of physical barriers, certainly one. Remember, I said it does not have to be a physical impairment in nature for students to qualify, but removal of physical barriers is certainly a common accommodation. Extended time for testing, usually capped at time and a half, meaning if a class is 40 minutes, the student with the 504 plan and that need would receive 60 minutes to complete a test, not necessarily in one chunk. That's also part of the accommodation. It could be adjustment of class schedule, can look like many things, rest periods, typically for physical needs, use of aids, and this does not mean people, it means the examples you see in parentheses, calculators, recorders, note takers, etc. Individualized homework assignments are a thing under 504 plan if necessary up through high school graduation. There's a little caveat to that I'll get into a little bit later. I would personally be careful, including that in a plan, but it depends on the individual needs of the student. More examples, health and safety procedures, particularly in this COVID era, I would say surely have taken on more importance, but some of these things here, administering meds, and usually that's going to be done by a school nurse. Special diets, always have documentation for these things. If there are emergency needs, we can plan for those as a team. Um, in the 504 plan, elevator key could be, is certainly one way we could remove the physical barriers talked about earlier. One of our questioners, participants said, alluded to staff training, and here you see it as an acceptable accommodation. Transportation, just as in the IEP. In an IEP, it would be under a related service. 504s don't have the sections like goals and related services and supplementary aids, but it's certainly transportation if a special need is available as an accommodation. And those related services, other things you might see in an IEPs under this particular section, PT, counseling, psychological services, speech and language services, certainly are allowable if needed and if data show necessary with a 504 plan. I didn't skip assistive technology. I wanted to jump back to it on purpose. I want to say that this broad area has probably never been more important in the virtual world which we inhabit, and for all its flaws, virtual learning, thank God we do have it. Otherwise, I don't know where we'd be in schools and as learners and as a system. I don't know where we would be. So the area, though, of assistive technology has never been, I would say, broader, partly because of the number of gadgets and tools that are available, and new things are always in development. It's like computing technology. No individual can really ever keep up with the whole of what's out there, but AT evaluations are something that I have more and more talks with families about on phones, as we try to, whether it's communication, assistance with writing, reading, whatever it may be, these things are being used more and more. It can be a formal evaluation requested by a parent for the school district to conduct. Some schools have AT personnel on staff, some don't, but there are community agencies in any area that the school district can use and consult and even contract with, to explore some of those needs. There are sometimes lots of trial and error involved in assistive technology evaluation and exploration, but there's never been more out there. So my thing would be, let's use it, folks. So this is something I put in here at the start of the pandemic. One of our questions referenced it earlier. All Section 504 provisions and grievance procedures remain in place. So nothing ever came out from the Fed, and that's who has the oversight on these things. Nothing ever came out saying you don't have to provide these accommodations. We don't have to carry out the process. No, one specific guidance document was issued in terms of timelines or the exceptions for schools being completely shut down, especially at the start of the pandemic. One thing that came up a lot, though, is that evaluation timelines may be extended, and we've seen this happen in schools, partly because a school didn't have a choice, being closed, number one, and number two, if we are talking about evaluating an immunocompromised student, and the student is not available to be evaluated or simply came down with a case of COVID, we can do some evaluations virtually, and some schools have transitioned to that pretty well. But some have taken longer and been delayed because we do need a student to be made available by their parents in some way in order to conduct an evaluation. And we'll get to grievance procedures in a little bit, but just a reminder that Section 504 is given to us by a federal law. That means states have no real oversight into what goes on in Wisconsin DPI will not really touch 504 plans meaningfully because of that. They, when contacted about 504 issues, would refer parents to the Office of Civil Rights, which will have that contact information later in the slides. So this one is for our visual learners out there, which I confess I am not that, but I will decode the diagram for you. The reason that it was put together, and we lifted this graphic with permission from another company, I guess circa 1999 it was developed, but the reason that the bright colors are here is that we want you to be able to see the largest circle is the yellow, the students with impairments. So that's anybody. A student can have some impairment diagnosed, but it may not even be found to substantially limit a major life activity, or the parents may never engage in a 504 evaluation because it may never be suspected or needed that a formal plan be put in place. So students with impairments, the general population is our very large yellow circle there. The orange circle within is the 504 eligibility area. So impairments substantially limit at least one of those major life activities we saw earlier. And then the IDEA circle in red is the students with the most significant impairments, perhaps more commonly spoken of as students requiring special education. So they have the IEPs, which we know have different qualifying procedures, but they do more and come with a greater amount of procedural safeguards. But in the spirit of inclusion, we want students with disabilities to be as included as possible, and the law requires it, and that they be educated into what we refer to as the least restrictive environment. So that entails that within these different populations, those on IEPs and being served by them would be the smallest percentage of the overall population. So why is this so important for everyone to know, regardless of the age of the student? If your child is on an IEP in high school, once a student either exits or graduates, 504 provisions are only available at college, and this is where we see them, sort of identified in that vein most commonly, or in the workplace. The protections the law gives us are still available there, even though you would not, as a practical matter, walk into an employer with a 504 plan. There are no IEPs after high school is the main point. So with that, that gets us to some examples of accommodations not provided in college. Unlimited time on tests. So remember I talked about it, the most common accommodation for extended time, which is available with proper documentation in college. The most common amount is time and a half, and that's pretty much where the hard cap is at the college level. So again, 40 minutes, if that's a class period and all students have one class period to test, the student with the time and a half accommodation would receive a full hour to complete it. Modified assignments or tests not provided in college, and this goes back to why I said I would be careful advocating for the modified homework assignments in at the K-12 level, because while allowed if needed, it's not going to be allowed in a post-secondary environment. So really look hard at the individual needs, and the goal of an IEP is that as you go on, goals would be met, success would be achieved with some of these things. And while the disability and all of its needs certainly aren't going away, the goal for students with college aspirations really should be to be able to fade some of the supports in the IEP in preparation for a post-secondary environment in which the IEP does not follow. Modified deadlines, not a thing. One-on-one aids not a thing in a college environment, nor are check-in, check-out with instructors. So this gets back a little bit to the legal basis, but through high school, under the Individuals with Disabilities Education Act, you have a right by law to services or programs. So if you have an IEP, they're said to be entitled to those services as long as the evaluation data and reevaluation data continue to demonstrate that need. In college, certain requirements must be met, so it's an eligibility standard, and accommodations are not a given just because you've got a diagnosis, say, of ADHD, and you're choosing to go to college. So a few key provisions regarding Section 504 in college and the workplace. The law is the law, so the foundation for equal access that we saw at the outset does continue to apply to courses, programs, activities, services, jobs, and facilities on campus. And then the ADA specific phrase that applies most often to the workplace is the right to receive reasonable, effective, and appropriate accommodations. And examples of reasonable accommodations, again, are going to be disability and individual specific, and they are many. But one example is, as a wheelchair user, I'll give you an example of something that would be reasonable, and that's that I had table seating to be able to fit my wheelchair effectively under a table in a lecture hall, so that I could learn and didn't have to cram into a regular desk or have limited space in a row of seats in a lecture hall. Something that would not be reasonable for me, from the employment side of things, would be, as somebody who has a physical disability that prevents driving, I can't apply for a job that is physical in nature, heavily physical, operating heavy machinery, driving a forklift, etc. Not a thing, because I have to be able to perform the essential functions of that job. But accommodations that I do use on my job, mostly that I self-accommodate, are I make sure I have all my required paperwork available to me in a Word format so I can type on the papers and submit them. And that's for the legibility for the people that need to read those things more than it is for me. But I need to be able to type as opposed to handwrite things. I need access to be low enough to a drinking fountain, for example. Those are examples of reasonable accommodations, which I am eligible for as long as I can perform the essential functions of the given job. So again, to sum this up, there are no IEPs in college or the workplace. I need to take the apostrophe out of that for if I have any grammarians out there. I see it. After high school, the only way to get accommodations is to ask, and this is why self-advocacy skills are really important for students to practice really throughout their school careers, but certainly before they leave high school, because most often it's going to be the student that has to initiate on campus the process of getting accommodations. Now, universities have discretion about what they want their paperwork to look like and what the point of contact is. Where I went, we had a point of key contact, and it was somewhat divided up according to their expertise and what disability we had. But students are going to be required to initiate accommodations. And this is really, you can begin practicing for this in high school, but also when you begin the process of deciding where you're going to attend. Even when you're in the application stage, you're going to be taking visits to schools, of course. And my recommendation has always been to schedule visits with whatever the disability accommodations office for students might call itself, to ask questions about the documentation that'll be required, because they need to see proof of disability, and it becomes more a little bit more medical in nature when you go to college. IEPs are still an acceptable form of documentation to give college personnel, but they often say they get more valuable information from like a privately obtained neuropsych evaluation, which is medical in nature, and it dives a little bit deeper into specific needs and how their learning needs might need to be accommodated in the college environment. But they're not going to come to you and ask openly what help you need. And one thing from hosting workshops and talking to many college providers I have learned is when they come to those as invited by me, they'll say things like, don't come to me at midterms when you're failing and say, oh, hi, I'm failing and I have a disability, and here's, I need help, or here's my documentation. These are things that need to be researched and acted upon during the application process, or certainly at the time of acceptance and when a student decides where to go. These are things that need to be acted upon, because as a higher ed learner, we need to be able to use our accommodations, make sure they're effective, but to hit the ground running and have success at that higher level. So before I get into procedural safeguards, I do want to add one thing from this previous slide. So I'm going to go back for clarity's sake. Most of what I just talked about, I will acknowledge that there has never been more options out there for students with disabilities who are significant, and post-secondary options that are designed as such. This presentation in particular was crafted for more traditional 2 and 4 year learning environments where you're going to be obtaining a degree. But if you're exploring, or that the nature of your needs is going to be that you're going to go to a college designed for a student with a more significant disability, and it's more, the experience of living on campus and getting additional vocational skills while you may be attending a program for up to a couple of years, such as UW Whitewater Life program, or Madison's Cutting Edge program through Edgewood College, just to name a couple, not endorsements. But if you're in those programs, the picture likely looks a little different. Certainly do the research and obtain the documentation ahead of time, but parents might be able to be more involved in such a process compared to what they normally would be. There's going to be paperwork, but if your child is attending but you have guardianship of them when they turn 18, that's going to allow the parents to be a sort of primary engager with the school on what the needs are, what's going to be a fit, etc. So the slides themselves here were crafted for more traditional environments, but we are seeing a bit of an evolution and expansion of those college experience programs, and we've actually done some of that, tried to offer a separate training for those families that are more interested or more in need of some of those options. But the bottom line is, regardless, if you're a student with disability with current and appropriate disability documentation, you do have the right to accommodations in a post-secondary setting based no longer on IDEA, but on Section 504 of the Rehab Act, as well as the Americans with Disabilities Act. So for now, we're going to move on because I want to make sure we have time for remaining questions and comments. So just a little bit about procedural safeguards. We talked earlier about how there are more of them under an IEP. So if you're in a position to where you're sort of poked by the school, or you're wondering about sort of making the switch from an IEP to a 504, know that there's going to be fewer safeguards, but the decision is not based on that factor. It's based on the data and the individual needs of the student. But as to point 2 here, this again is why the district is required to have written procedures for grievances and conflict resolution, and then that central person, the compliance person, 504 coordinator, can supply you with that information online or a copy. But this is definitely one that if it's not in writing, it doesn't exist. So do all of the diligence and follow-up that you have to if you find yourself in this type of position. So what do you do? And this is more back to the K-12 side. What can you do if there is a problem and you've decided you need grievance procedures? These are the three that you see here. So point one, you can ask your district to conduct a hearing for parents who disagree with any part of the 504 process. So that being the identification of disability, the evaluation process. We ended it here with placement, but that's what that really is the last step in the development of a potential 504 plan. If there's a disagreement there or in any one of these areas, you can ask for a hearing. But the district essentially, it is required to be an impartial hearing, but the district does essentially control the terms of that hearing. So anecdotally, and I do emphasize that word, I typically don't hear a lot of situations in which the terms of a hearing like that has been successful. So that is why there are two more potential grievance procedures. You can file a complaint with the Office of Civil Rights. On the next slide, we'll have the contact information for the Office of Civil Rights that is closest to anywhere in Wisconsin. Spoiler alert, it's in Chicago, but you'd be engaged in a process by phone or online anyway. So that part doesn't so much matter. If both of those fail, and anybody has the right to pursue legal action at any time. You would need to find an attorney for that. It would be in federal court. So I pretty much always advise parents when confronted with this circumstance to somewhat to try these in order, unless I get a call at the point where the first one has already been tried. But I don't think I've ever said in nearly 13 years to pursue option number 3 here first. But these are the grievance procedures that are available to parents embroiled in a dispute in any one of these phases of the 504 process. And as promised, here is the contact information. OCR is a division of the Federal Department of Ed, so you see the contact information here for the Chicago office. I hope it still has the fax machine. I should probably take that out. But you see that information there, and that is as opposed to, again, Wisconsin DPI has a complaint department, but it's for IEPs and anti-discrimination complaints within school districts, not anything to do with the administration of 504 plans. So the Office of Civil Rights is your go-to if you're at that stage. And here's the information to contact Facet's main office. If anyone listening wants to call to dive into some deeper questions, you may do that in those methods. And for additional resources on 504s and other things, you may visit our website. I see we have a couple of comments. That's good. Let me open this back up. Okay, right now we have one, but keep those coming, particularly if they concern the second half of the presentation. This commenter, I'm going to say, if you want to address that further, please comment our help desk. It has to do with the reading and the administration of IEPs. So I want to stick in our last Q&A time here to answering 504 specific questions, but by all means, feel free to contact me individually if you have more that you need to talk through, and I'd be happy to get you to next steps. And thank you again for your participation and the comments. And actually, at this point, I'm going to go ahead and stop the recording. I see someone else chiming in. I'll get there in just a second.